Mr. Ware.
Please, my Lords. The issue I turn to then is how the appellant's conduct involved active concealment. And the first question is, can the respondent rely upon the analysis of Lord Justice Mayall's at 180? And you see that if you go to page 220, please. It's para 180, but page 220. Present case, the parties agree the bank's failure to disclose the commission was not a case of active concealment, but only of non-disclosure. For my part, however, if the question has to be asked, I don't consider the answer is correct. The bank went to considerable lengths to ensure that the claimant would not know about the commission, and that's a reference back to para 171 at page 218. I'll come back to all that in a moment. The test on withdrawal of concessions, as my learned friend rightly says, is helpfully set out in FII 2 at page 737, or 735 to 737. In essence, is the new point a pure point of law? Would the earlier introduction of the point have involved the adduction of evidence or trial being conducted differently? And has the other side had adequate time to deal with the point? In response, the respondent submits that first, it's a pure issue of law going to what constitutes deliberate concealment. That's the issue. And as part of understanding what constitutes deliberate concealment, the court is considering whether a freestanding duty needs to attach to the omission to disclose in this case. That's where the interest in the description active concealment arises. Secondly, the trial would not have been conducted any differently. I've explained and taken the court to the agreement to show that Mrs. Potter entered into her fixed sum loan agreement, which was a single loan made up of a loan for cash and a loan for the PPI, and that was page 286, the loan agreement.
I'm so sorry to pull you back to your first point.
Yes,
you said it's a pure issue of law, what constitutes deliberate concealment. And then you talked about, does a freestanding duty need to attach?
Yes, my lord.
Sorry.
Yeah, shall I explain what I mean?
Yes, if you could. Sorry,
yes.
I just didn't.
The current position, this is Court of Appeal analysis as opposed to our additional case, is that you divide up between active concealment and, I say, mere non-disclosure. If it's an active concealment case, you don't need any of this additional duty. You have deliberate concealment or not. If you haven't, someone who, the paradigm would be a misrepresentation. Because when you're dealing with concealment of facts as opposed to commission of a breach of duty in circumstances that won't be found for some time, you're very often dealing with conduct of a professional. If you look at the cases, it's invariably a professional like a solicitor. Something has happened. In the paradigm case, it's happened earlier. We'll come back to the does it need to have happened earlier part in due course. But so let's just take the solicitor who has let the claim be struck out. If it's it's an unhelpful analysis because the solicitor we know to be under a duty, but if the solicitor engages in an active misrepresentation, your claim is alive, then it's common ground, I believe, that there be no need to establish a duty to disclose.
Just at the first point as to what the legal test would be, I'm looking at section 32(1)(b).
Yes, my lord.
It's deliberately concealed any fact relevant to the plaintiff's right of action.
Yes, my lord.
So what do you say the active concealment has to relate to?
The act of concealment relates to the fact. The fact is the fact that's relevant by common ground. The fact that's relevant to the cause of action is a non-disclosure of the commission. So has there been an active concealment of, and it sounds a bit odd, but the non-disclosure of the commission? That's on this case. The reason that the business of duty arises is because if on the current law it's not an active concealment, it is a mere omission to disclose, then it is common ground that per the current law there needs to be a duty to disclose. But the question is whether that is a Limitation Act duty or a legal duty. And that's what I was referring to, my Lord.
But does, just as a proposition of law at yes, the first point that you're on, does the active concealment have to be something which on this alternative case, the defendant appreciates is a fact which is relevant to the plaintiff's right of action?
There's no suggestion that that's the case, no. Not that I understand it, no. No, right. I mean, it's all part of the wonderful ambiguity that lies within section 32(1)(b).
Right, I'm just trying to understand what you're saying at the moment.
But if it's active concealment, I mean, I'll allow my learned friend, obviously, David's reply to say what he whether he accepts this, but I have understood. I mean, to be fair to him, he's essentially not been faced with a case of active concealment as he understood it, so his submissions are limited and he's very much gone for the you can't have it more than the detail of it. But I would understand him to agree that if it's active concealment, you don't need the additional mental elements, whether it's a mental...
No, I have to say, I noted, admittedly, towards the end of Mr. Cummins' submissions that he didn't accept that.
Well, I mean, if it's active concealment and you don't need a duty to disclose, it's very much an oddity if you then need to know or be reckless as to your non-existent, not needed duty to disclose. So I have struggled with that.
No, but we've moved away from duty to disclose.
Right, if it's fact relevant to, then all we have is obiter dicta from Lord Justice Mance investigating this. That's all we've got. We'll come to decree palm in due course, but the decree palm is treated as if it's sacrosanct, that it's been there forever, that the law has always been crystal clear. It's a bit like offer, acceptance and consideration for the more primitive as in issues of contract law. It isn't.
Right. Still focusing, if I may, on the case you're now presenting, which is active concealment.
Yes, ma'am.
Are you saying that the active concealment, what has to be deliberately concealed by the defendant, is just any fact, and then as a separate, if you like, objective test, it has to be turn out that fact is relevant to the plaintiff's right of action?
Yes, if it's active concealment, my lord, yes.
Right.
Active.
I certainly understood Mr. Cummins to be presenting at least one of his arguments.
That has been lost by me, I'm afraid.
Anyway, thank you.
But I will seek to meet, in any event, the issue of a mental element, insofar as it is anyway required, even in a case of active concealment, that there be knowledge or recklessness as to it being relevant to a cause of action. So I'll make submissions on it anyway, my lord.
Right.
It wouldn't be, if you like, deep into this part, it wouldn't be my primary case that's required, because again, it'd be a matter of honouring the language, and the language in no way on its face requires that. And then you'd be having to ask yourself the question, which is just the analysis of Lord Justice Mance and Williams. Nevertheless, in order to meet the statutory purpose, do I need to provide additional barriers to the application of 32(1)(b)?
Yes, thank you.
I'm sorry to sort of dart about, but in 32(2),
yes, ma'am.
What do you say in the present case the breach of duty is?
I'm sorry, ma'am, that was lost.
Oh, I'm sorry. In 32(2),
yes, ma'am.
What do you say in the present case is the relevant breach of duty?
My lord, it's the non-disclosure of the commission in circumstances where it would be reasonable to disclose it in the interest of fairness, and that's the Plevin sense. So what we've got for commission of breach of duty rather turns, my lord, on whether or not we're looking through the prism of the Court of Appeal, which says reckless as to legal outcome, or the prism of our additional case, which says knowing the constituent elements of the cause of action.
Mm-hmm.
That makes sense. And that's why I took your lordship through, your lordship will recall, I went through a sort of working example of this case under 32.2. The bit where I went, the defendant didn't disclose the factor amount of the commission. This was my 32.2 additional case. By that route, it didn't know of the existence, the claimant didn't know of the existence of the sum, the defendant safeguarded its lucrative business. In other words, it made profit from the excessive commission it would otherwise not have been able to make if it had made a disclosure. And that's what constituted the unfair relationship. And so the breach of duty is knowing that part on our additional case. On the meaning attributed to it via the Court of Appeal analysis, it's reckless as to the legal consequences of that.
Yes. Yes. So if I've been looking at Lord Millet and Cave, and
yes,
he takes the view that in a negligence case, the breach of duty is the failure to take reasonable care. So here, in a case of this kind, the breach of duty is the non-disclosure of the commission, and you say that, well, if that's deliberate, then you're home and dry under 32.2.
Well, I'm home and dry because anyway, we have all those findings from the record I took to court to, including paragraph 27. It's not even just non-disclosure of commission, it's non-disclosure of commission knowing that it is in a Plevin sense unfair not to disclose it. That's not knowing that you're legally obliged to disclose it. It's knowing the essential elements of the claim.
Yes. Well, I'm not sure if you even need to go that
well,
far.
That's obviously those are matters for the court, my lord.
Yeah.
So I hope I've addressed the questions of my Lord Sales.
Yes, thank you.
I was then going to the issue of whether the trial would have been conducted differently, explaining that the claimant entered into a single loan, incorporating a loan for the kitchen or whatever, and a loan for the PPI. And the loan, the single loan sold as a package, was sold to her via a non-advised telephone sale. So it wasn't sold electronically on the internet because it's Egg Bank, the first internet bank, contrary to the submissions made yesterday. And that's in the defence at page 275. But down at the bottom at 3.2 and over the page to 276. So 275, you're in the defence. Right at the bottom, it's denied the claimant entered into any negotiations prior to entry into the loan. The claimant obtained the loan via a non-advised telephone sale. And accordingly, there were no negotiations with any servants or agents of Egg Banking Limited. Now, a non-advised telephone sale means simply that the appellant provided information about the PPI, but did not actually recommend that it was suitable. There's an additional world of pain for creditors who then recommend a PPI in which they're getting 95.24% of the commission. It wasn't one of those cases, and that's what non-advised means. But it's one where strictly they provided information about it. Obviously, Mrs. Potter had no idea about a PPI until she applied for a loan, and then it's, I'm going to give you information. You can get a PPI loan at the same time. So that's what it is. So there were discussions between a telephone sales operative and Mrs. Potter, and so Lord Justice Mayles, when we then go back to page 218, paragraph 171, was not, respectfully, we say, wide of the mark at all, because it's obvious, quoting from him, this is para 171, page 218, that a decision was made at a senior level with the bank that the extraordinary level of commission should not be disclosed to customers, that salesmen and account managers were instructed accordingly. That's a very natural inference to draw, and there have been a lot of inferences drawn inevitably because it's a case in which the defendant elected not to call evidence. The respondent's reply in our respectful submission was adequate to cover a case of active concealment, page 283, I'm not saying those words were used, but if you go to the reply to the defence at page 283, paragraphs 8 and following, honouring the language of the statute, the defendant deliberately concealed the levels of the commission it received from the insurer in respect of the policy at the time of sale. Further, it didn't disclose to the claimant whether commissions were paid and received, etc. Para 11, in the premises is averred the defendant deliberately concealed facts relevant to the cause of action. That's not a pleading which says there is no possibility of your understanding that this is a case of active concealment. It's a case of honouring the language of the statute, and para 12 even made reference to its averred that the concealment was deliberate on the basis the defendant can be presumed to have made a commercial decision not to inform customers of such commission payments, in all likelihood because such information would undermine their customers' assessment of the value for money of the policy and or cause them, the customers, to decline to purchase it. And essentially, that's exactly what Lord Justice Mills is saying. That's it. Commercial decision was made to make sure that the customer doesn't discover. And that's the essence of para 171. And faced with that pleading, the appellant elected not to call evidence. See the recorder's judgment at paragraph 7, page 250. You don't need to turn it up unless you wish to, but it's page 250, para 7 of the recorder's judgment. And then thirdly, the appellant has had time to deal with this. It's put in its written submissions in response. I would add that, as described by the appellant in their case at paragraph 3, this has certainly become a test case. The indication in paragraph 3 that somehow that's been driven by the claimant is entirely wrong. All that happened in this case was Mrs. Potter brought a claim in a small claims track for recovery of sums under section 140A to C, and she won, and ever since then the appellant has been appealing, because we've won at every stage. And every single time we resisted appealing, I think by the Court of Appeal to Supreme Court, it's entirely obvious this was a Supreme Court point, and we may not have resisted permission to appeal. I can't remember at that point, but every step of the way otherwise, appeal's been resisted by the claimants. It's not a test case from the claimant's perspective. It has become a test case because the defendant is elected to grasp this particular case of Mrs. Potter and to run with it. But it being a test case, that is something which should influence, in our respectful submission to the court, in analysing whether it wants to hear all the arguments. Otherwise, there could be the possibility of, well, we didn't deal with active concealment, and then cases have to get run all over again on the basis of their active concealment, and what difference does it make? Which wouldn't be helpful. So if I can then turn to the substantive issue. In Williams and Fanshawe, if your court can kindly go to page 826, paragraph 39. This is where Lord Justice Mance distinguishes, we say, between what he calls active misconduct and mere silent withholding. And you'll see that if you kindly just read para 39, which will be quicker than me going through it. You'll see second line and about halfway down. And in Cave, at page 528, paragraph 25, in the judgment of Lord Millett. So page 528. para 25, Lord Millett at E says, Section 32 deprives the defendant of a limitation defence in two situations. One, where he takes active steps to conceal. And so our understanding of the position is that the distinction is not between acts and omissions per se, between misrepresentation against non-disclosure. The issue is whether or not the defendant took active steps not to disclose or merely omitted to disclose. And this language goes right back. If we go all the way to Kitchen at page 606, here in the judgment of Lord Justice Sellers, and in the second new paragraph or complete paragraph, so just above halfway down the page, and in the middle of that paragraph, but in October and November 1946, there was active concealment, a deliberate and intentional failure for some reason to disclose the offer of £100 made by the West Kent Company. That's the case of the ex gratia payment. And that's described as active concealment, but it's an omission case.
Give me the page number again, I'm sorry.
My Lord, yes, 606. So if one plays with this concept, you can have a written agreement, as there is in this case, drafted by the defendant, as it is in this case, which excludes any mention of the commission, or it could have included reference to the commission and redacted it, and it could have redacted it completely, or it could have redacted it with thick black line left in the contract. The position is materially the same. There has been an active determination by that party to ensure that the contract will not make reference to the commission, and ditto in the context of the telephone salesperson in this case. See the finding of Lord Justice Mills as per the pleading in the reply. And that, we submit, is going to the essence of what's meant by active concealment, as opposed to perhaps like in negligence and the distinction that my Lord Reed has drawn, and making matters worse and not making them better and so forth. Don't really just carry over in this area conveniently when you're looking at the target that we're engaged in. The target is one of whether it's active concealment, and that is active concealment. So yes, we absolutely owe it to Lord Justice Mills to put us on the right path, but having been put on that path by him, we seek to pursue it. His finding is absolutely, his Lord Justice Mills' finding is absolutely of a piece with the findings of the recorder at paragraphs 24 and 26 that I read out before, which is at page 254. It's not like he's, in that sense, really broken new ground. That was the reference to a sophisticated creditor, page 254, 24 and 26. The decision as to what commissions charged and not disclosed must have been considered at a high level. There's no evidence from the defendant to gainsay such inferences. And I've referred you already to Mr. Justice J at 28, saying it's obviously for commercial reasons.
And it's a matter in which the customer plainly had been interested and might have affected the customer's decision whether or not to proceed.
Oh, it's, I mean, one asked and answered, I might say, my Lord, absolutely, because, I mean, this is the information that is at the heart of the case, and not the case on limitation, but so much as the 148 case, absolutely. And that's in this relevant sense, because we have to keep remembering, if I can make this submission, that this is all, I don't know if construct's the right word, but it is all in the context of the court seeking to interpret the words deliberately concealed, which don't say active concealment, passive concealment at all. They just say deliberately concealed. And Lord Justice Mills is saying, I get that, and I'm just going to apply it. This is active concealment. I don't need to root around. But he's in the Court of Appeal, so he has to follow what he's been told to follow in the Court of Appeal. And I don't have to root around in that context at all for a duty in Limitation Act terms or legal.
Can I just be clear on this? It seems to me that the submission you're just making actually does depend quite importantly on your answer to my previous question, looking at section 32(1)(b). The deliberate concealment, you say, is just of any fact, and later it may turn out that that fact was relevant to the plaintiff's right of action. If, on the other hand, what has to be concealed is, in a deliberate way by the defendant, is taking the language together, any fact relevant to the plaintiff's right of action, i.e., if that imports some consciousness that the fact is relevant to the plaintiff's cause of action. If you're looking at what the recorder was talking about, as I understand it, he was talking about the initial transaction, and that's at a stage when there is no relevant legal liability because Section 140A comes into effect later on. Have I understood correctly that that's the way your submission fits together?
Broadly, yes, but the concealment, let's take April 2008 rather than April 2007 with that, so I don't only have to have the problem of April 2007 to April 2008. I'll just take from April 2008 when we know that it applies retrospectively. From that date on, there is concealment of A, the ongoing unfair relationship, and B, the ongoing unfair relationships in the past.
Doesn't that then depend upon examination of states of mind, not at the time of the transaction, but from 2008 onwards?
Yes, madam. That makes sense, and that's been covered because the recorder, as I recall, says from 2006 onwards, not in 2006 only. It's para 27. As from, at and from 26 July 2006, the defendant must have and did know. Para 27, my lord, page 254.
It's overturned.
Right.
And I'm going to get to my post-Supreme Court case, but for the avoidance of any doubt, he sees that all the way through to post-2014, see para 30, which I emphasise now because it shows you that he's seeing it all the way through.
But just going to the point that we're on, that you're asking for permission to raise this new case.
Yes, my lord.
If this had been the case presented previously, would there not have been scope for the defendants to call evidence to say, whatever we thought as at July 2006, it didn't occur to us in 2008 that we should have been disclosing at that point in time?
My lord, I sought to meet that potential submission already by explaining that the reply to the defence incorporated active concealment because it was a pleading relating to deliberate concealment, not limited to omission. And I took you to the paragraph in which it was even pleaded that they had required their team, in effect I'm paraphrasing now, but I guess go back to it, the para 12, page 284, such concealment was deliberate on the basis the defendant can be presumed to have made a commercial decision not to inform customers of such commission payments, in all likelihood because such information would undermine their customers' assessment of the value for money of the policy. And that comes before the decision is made by the appellant not to call evidence. So it does not lie in the mouth of the appellant say, now you put it in that way, I would have called evidence, because it was not put in that way before. That was the submission I was trying to make, Lord.
Yes, thank you.
It's an important one. I mean, if they had a case for I would have adduced evidence, and I would understand, that would put me in very big difficulties. Well, I think the court would simply resolve it against me. So that's our case in relation to active concealment. And even if active concealment then embraces a mental element beyond active concealment into active concealment with mental element attaching to concealment of the fact is relevant to a right of action, I'll come to that, if I may, in due course. So if the court's against us on active concealment, but only if it's against us, the question arises whether there is a legal duty to disclose that's required or whether it's a Limitation Act duty. But I do understand, my own friend, to accept that at that point in time you don't need any duty if it's active concealment. My first submission is that as a matter of ordinary language, there is no need for an omission to disclose to be coupled with a duty to disclose, any duty to disclose, in order to qualify as concealment. And there we pray and aid the analysis of Lord Justice Mells that you've just seen at para 172, not 171. So page 218, please. And it's after the first line. It's the rest of 172, but if you can kindly read that. I won't read it out. But that is not framed in terms of duty, this sort of absolutely a duty required. It's framed much more in terms of asking the question that the statute demands, has there been a deliberate concealment? Setting out the facts of this case and going, that's deliberate concealment. And that is what we've sought to mirror with our additional case when I come to under 32(1)(b). Court's function is to look at those words and answer them. You don't need to go through these hoops and hurdles of duties and so forth. I note...
Sorry, can I just ask you?
Yes, ma'am.
Might it not be said that that sails quite close to the Brocklesbury approach? Because it seems to be saying, well, you just need actively to have thought, I'm not going to disclose facts. So, of course, you know you haven't disclosed facts, and then the test becomes one of reasonableness.
Well, my lord, the test of reasonableness is not just Brocklesby. The test of reasonableness is the way in which we've sought to promote our additional case, is to introduce, and I will come to this, but I'll deal with it now. We introduce the test of reasonableness to explain when non-disclosure converts to concealment. In other words, when someone deliberately non-discloses in a way which is objectively unreasonable, that is a deliberate concealment. And we hope, perhaps that chimes to the court, perhaps it doesn't, but we hope that meets the demands of Parliament to set a fair balance between the parties. That's how...
But I mean, doesn't that submission move quite a long way away from the connotations of the word deliberately in section 32(1)(b)? I mean...
Because it's a deliberate non-disclosure.
Right.
And we have what we've called a primary and secondary case on additional case. In the secondary cases, you need to establish deliberate concealment, where concealment is non-disclosure that's objectively unreasonable. Our first case is you need to establish deliberate non-disclosure, where non-disclosure is objectively unreasonable. But both incorporate a sufficient and proper mental element and objective element. We submit, but it obviously matters for the court. It's a big section, and a lot of thought will need to go into finding the right answer. But that's our attempt to fashion a route through which respects the language.
Yes, thank you.
Can I just ask you? I understand the significance of whether there's a duty to disclose as a matter of general analysis of Section 32. In the circumstances of this particular case, your whole cause of action is based on there being a duty to disclose.
Yes, it is, my lord.
If there's no duty to disclose, you don't get off the ground.
Well, we've always recognised it's an unusual case because it's a case in which duty to disclose forms the substance of the claim.
Exactly.
Oh, absolutely. We've been very open about that from the off.
Yes.
That's an unusual feature. That's why when Malone, for instance, says, oh, you can't have 32.2 marry with 32.1 and be in this way, he's not going to marry that often. We're in a very unusual case. There's another working example of it, which I'll come through from Lord Justice Mayles, of a cartel.
Yes. So it seems to me at the moment that the question whether there could be a duty to the question whether there could be non-disclosure absent a legal duty to disclose is one of general interest. It's actually academic on the facts of this case.
We say it's completely academic, but because we say it's obvious that there's a legal duty to disclose in this case. Yeah. That is an issue between the parties. And so we've had to go through all these wonderful hoops and hurdles of saying, is it an act or an omission? That's the additional point. If it's an omission, is it a limitation act duty or a legal duty? That's why my third submission was, in any event, it's a legal duty. So absolutely, my Lord. And that's why I've made a submission earlier. It would obviously be a matter for this court as to whether it wishes to go for the all-embracing judgment explaining all aspects of 32.1b, or whether it chooses to take a narrower course through this appeal, and that's obviously entirely...
Yes, I'm not being critical at all. I just wanted to be clear in my own mind.
That's exactly right, my Lord. So some things just don't arise. And as has already been accepted, if we went on 32.2, we went on 32.2, the court could down tools at that point. It's a matter for the court. I think it would be helpful, enormously helpful, in the Supreme Court's role in clarifying the law, to clarify an incredibly opaque area of the law that's of general importance. I mean, obviously it's in this court, but it's so obviously of general public importance, Section 32 of the Limitation Act. Well, in terms of this business of do you need a legal duty to use the word concealing, it didn't escape our notice that a case referred to by learned friend in his additional submissions called Smith and Hughes contains a passage that the court will make of what it will, but it's at page 2523. So we're now in page 2523. We're in a case called Smith and Hughes, which is from 1871. It's a case that learned friend prays in aid for the caveat emptor, silence is golden principle, which I might say may apply generally in contracts, but certainly doesn't apply in consumer law. And on page 2523 near the top, the court will see, if the court now has this, Mr. Justice Story, in his work on contracts, states the law as to concealment as follows. The general rule, both of law and equity, in respect to concealment is that mere silence with regard to a material fact which there's no legal obligation to divulge will not avoid a contract, although it operates as an injury to the party from whom it is concealed. So as I follow that, Mr. Justice Story had no difficulty with the idea that an omission to disclose in circumstances where there's no legal duty to disclose can probably be described as a concealment. As I say, the court will have to make of that what it will. But that's how we read that. So we do, at this point, part company, and respectfully so, from the observation of Lady Justice Rose at page 191, paragraph 75. When in the middle of 75, she says, for the purposes of the Act, that obligation... Oh, no, sorry, earlier on, when she says, so second sentence of para 75 at page 191, Section 32b does not refer to a duty to disclose, it refers only to concealment. Inherent in the concept of concealing something is the existence of some obligation to disclose it. Does the court see that? That's just line 3 at para 75. Respectfully, we say that's not correct. That's not inherent for the reasons I've just made, submissions I've just made. And we say, see the judgment of Lady Justice Arden in Giles and Rhines. This is page 554, paragraph 36.
I'm so sorry, what was the page?
Yes, my lord, it's Giles and Rind. It's page 554. It's paragraph 36. It's at B. And she's obviously considering 32(1)B as well. And she says, the expression concealed must bear its normal meaning, which is that something was actually hidden from view. And we say that is the essence of it. It's not a particularly easy word to define. I mean, many words in English language are not particularly easy to define because there's something in concealment that encourages us in certain circumstances to use the word concealed rather than not disclosed or even hidden. But that gets to it. It's keeping hidden or making secret or keeping secret. And that does not require of a duty, even when you have, in that sense, you've taken active steps, it's active in something we say, but even if it's an omission, because you're just looking at the fact that it's a non-disclosure, there's no requirement within those words, which obviously don't appear in the statute, but there's no requirement in the words non-disclosure that they be attached to duty. And we respectfully submit that Mr. Justice Park was, and this isn't not intended to sound patronising, but heading in the right direction at paragraph 14 in Williams and Fanshawe, it's page 818, when he explored how there could be concealment by omission beyond in circumstances where there was a duty to disclose. It's between B and C. So page 818, he says, I would go further and accept the fact which he decides not to disclose must be either one, it was his duty to disclose, or, and then he goes on. Now we say this isn't the test, but he's exploring and recognising that it doesn't only occur in duty to disclose cases, or must at least be one which he would ordinarily have disclosed in the normal course of his relationship with the claimant. And we say that's a helpful example as opposed to a test. And that again that's a sort of judicial intuition, if I can put it that way, in play. And as a matter of authority, we say there's no requirement for there to be a legal duty to disclose, only a duty in Limitation Act terms, and that takes us to the Critty Palm. And I know or anticipate that your stamina for more submissions on the Critty Palm may be limited, and can I seek to do this in as short an order as possible. First, I'm just going to give you the reference to the judgment of Lady Justice Rose, because she analyses it in great detail. Paras 68 to 78, starting at page 188. And that essentially, apart from her use of the words morality and utility, which she borrowed from the judgment of Lord Justice Ricks, mirrors the submissions that we made before. But can I now jump in straight into the judgment of Lord Justice Buxton? A lot of time was spent on Lord Justice Ricks's judgment. We accept that Lord Justice Ricks believed there to be a legal duty. That's not an issue. That was Lord Justice Ricks' analysis. There needs to be a legal duty, and there isn't in this case. But since Sir Martin Norris agrees with Lord Justice Buxton, we're going to find the answer in the judgment of Lord Justice Buxton. And if you can pick it up, please, at 472, page 472. Near the top, at para 427, Lord Justice Buxton asked himself the question at 2, at 1, was ITS under a duty? But that was a neutral expression. That tells us nothing. That doesn't mean he said the word duty, ergo it's legal duty, which I think was the thrust of the submission made yesterday. That tells us nothing, because that's him setting it up for his analysis, the analysis of which is the part that's agreed with by Sir Martin Norris, is as I agree with what he says from 428 onwards. And then when we go down to the bottom of 429 and the beginning of 430, That question was not framed in terms which are helpful to the inquiry under the Act. The issue there, and in this case, is not whether ITS acted in an advisory capacity to Mobil and AIC, because plainly, apart from its obligations as certifier, it didn't do so. Nor is the question of whether, in the terms of the Act, ITS had a duty to reveal the Cooper retest necessarily determined by reference to ITS's contractual duties. That is the first time that Lord Justice Buxton says, in the terms of the Act, and it is a phrase there or thereabouts that he then repeats, because he understands straight away that the question is in terms of the Act. It is simply untenable to submit, as my learned friend has done, that what Lord Justice Buxton really had in mind was a tortious duty. No mention is made by Lord Justice Buxton of a tortious duty. His point is just to contrast duty within the terms of the Act with contractual duty.
In 428, he refers to duties imposed by various international standards and practices.
Lord, yes. Because it's why he uses the expression "and in common sense." He's looking around for, is it appropriate to hold them to a duty disclosed for the purposes of the Act, which is, this is all a construct. This is just to say that, that an omission to disclose constitutes a deliberate concealment. It's not for any other purpose. It should come as no surprise that Lord Justice Buxton is not looking around for a tortious duty, because if I understand the position correctly, and will surely stand to be corrected, when you have a contractual relationship, the tortious duty will mirror any implied term under the contract. And my Lord Sales may remember, certainly in Dryden, in the Supreme Court, I argued in light of the judgment of Lord Justice Sales that, as it then was, that any duty to protect the employee from economic loss was the same whether it was argued for in tort or contract. It has to be, because that's how it works when you've got a contractual duty. You're not going to have a tortious duty that's at odds with what you would imply into the contract. So nothing is gained by this idea that, oh, really he had in mind something called a tortious duty. That's why Lord Justice Ricks, at page 456, answers the question in short order by simply saying, in sum, para 351 at the top, I do not think there was a contractual duty of disclosure. Full stop. Because that's the end of it from his perspective. There really is nothing in this, it's a tortious duty. At para 440, we have the reference between C and D to hold as I would that he was under a duty in Limitation Act terms to reveal that material. Doesn't open any floodgates.
Which page is that?
My Lord, it's 475, sorry. 475, end of para 440. 443, I'm therefore satisfied in the sense relevant to the Act, interpreted in the authorities set out at 426, that ITS had a duty to reveal to AIC.
Sorry, where's that?
Para 443, page 475. That is language, the intention of which, in our respectful submission, is sufficiently clear. Lord Justice Buxton is not seeking to identify a contractual duty. He's seeking to identify a duty for the purposes of the task he's faced with, which is a limitation task, and to determine whether an omission to disclose constitutes deliberate concealment. That's the question he's being asked, and that's the question he's answering. And in that sense, I can't use freestanding because we've been using freestanding as a freestanding legal duty, but it's a self-contained issue. He doesn't need to go back to the contract to look to change the law of contract, or as points Lord Justice Ricks made, far-reaching implications for contractual relationships in all these sorts of contexts. It doesn't need to do that. It doesn't need to go around in another case and find the existence of a duty of care, which is normally a Supreme Court point. Anything beyond the considered categories ends up here. Any new category of duty of care is a really substantive point for the courts to grapple with. That's not his task. His task is to understand whether a non-disclosure constitutes a deliberate concealment. The only succour my learned friend can really get is from the same page 475, para 439, but at the top of page 475 between A and B. The court can see that, where it starts not only as a matter of law, but also commercially. It really challenges reality to think that a certifier, etc. And that I would describe as the high watermark from a learned friend. And that language, we say, is a reference to as a matter of law under the Limitation Act, not as a matter of general brackets contractual and or tortious law.
So can you help us with what test you say applies to identify the non-legal duty? You're saying
yes,
it's a duty in Limitation Act terms.
What's the content of this so-called Limitation Act duty?
Yes, that's...
Yes, the content of it is exactly as Lord Justice Mail says, is somewhat elusive. And that's part of driving towards the additional case that says convert this into an objective test of reasonableness, which may be a more effective tool for the court, and that's why we promote that in additional case, because you ask, has someone deliberately concealed or not disclosed, depending on which of our tests you go, and then you convert it into, then you ask yourself the question, is it reasonable not to have disclosed in those circumstances? Because there's no doubt that it's elusive. I didn't create it. It's been created through the Critty Palm.
And just on that, you referred us to Ms. Justice Park's judgment.
Yes, ma'am.
And said that was signposting in the right direction. I think that was the part of the judgment which Lord Justice Buxton put to one side in paragraph 426 in the Critty Palm, isn't it? So this is at page 471.
Part of the joys of the Critty Palm is that this is where you end up, and
right. But the point I wanted to put to you is that the second limb of Miss Justice Park's test looks stricter than a simple reasonableness test. It's a disclosure which the defendant would ordinarily have disclosed in the normal course of his relationship with the claimant. In other words, that's what he would have done, not a matter of reasonableness. And yet that is being put to one side by Lord Justice Buxton in Critty Palm as being controversial. Your test seems to be even wider than that.
Well, if the court considers it to be even wider, I would have thought, respectfully, the court may think it's a mechanism for controlling, as opposed to I wouldn't use the word wider, I would more use the word controlling, because the way in which we set it out in our written case is the court would then take into account a range of the relevant evidence of what the defendant knew, what the defendant didn't know, and so forth. You put all that into the pot, whether there's a legal duty, whether there isn't a legal duty, in order to make the assessment that it should reasonably have been disclosed or not, because you're simply answering the question, was it deliberately concealed? So is a non-disclosure a deliberate concealment? And you're trying to answer that question, and it's more a question of taking what has happened and analysing it, and if you're going to analyse it, set it against something, it seems more attractive to set it against an objective test by the court, so the court can make that assessment. I've used the description has a free hand to, and that's been taken as a stick to beat me on the basis that that's just me encouraging free discretion contrary to certainty. That's not the intention at all. That's just saying the test is clear, The application of it will no doubt be developed through case law, but it's a mechanism for control by the court.
Yes, thank you.
In our respectful submission. Because otherwise, the trouble is, you can always have, as my learned friend promotes, a tighter and tighter case that of very little application that therefore can be argued promotes certainty. But if the only cases in which Section 32(1)b bites are those in which there is a legal duty to disclose, we're fine in this case, so in that sense I can walk away. But as my learned friend pointed out, Lord Justice Ricks makes the point, there are very few occasions in which a person's under a legal duty to disclose like that. So it's essentially limited to solicitors, in cases of ongoing fiduciary duty or the like.
Yes, although I think it could be said in relation to that, of course the duty to disclose is actually something of an extension beyond deliberate active concealment.
That's the point, my lord, that I'm really coming back to.
Right.
These are all add-ons. That's the complaint I'm really seeking to make. It's been put against me. Well, hold on, the Critty Palm says Limitation Act duty. What does that mean?
Right, but I was just...
said it, not me. It's the test the court wants to apply. We've offered up as an alternative. Cut through this. Cut through these strange 3-4 stage tests. Get back to the statutory language. Ask yourself exactly as per the observation of Lord Lascelles, has there been deliberate concealment? And if the court considers it's appropriate to attach to that an objective test of reasonableness which explains when non-disclosure becomes concealment, that would seem respectfully to us to be a sensible position, but these are matters for this court.
Yes, thank you. I understand that submission. I was just seeking to press you on the point that you had just made, that somehow it's an objection to deciding that the criterion is a legal obligation to disclose, that it's going to be a narrow class of case.
Yes, my lord. And
what I was putting to you in the context of that submission was, is that necessarily an objection, given that the class of case of acting in breach of a duty to disclose is really being added on as an extension from the basic concept, which is deliberate concealment?
I do apologise, because I'm just not getting traction on where... I agree the test is deliberate concealment. Right.
And you're now in your submissions where you've moved on from your alternative case, that this is directly a case of active
Yes, so we're treating this as a pure omission case.
And so we're treating it as an omission case where that has to be a duty.
Yes, my lord.
And you were saying, well, the duty must be a wide duty, because otherwise, in a pure omissions case, you're only catching a small class of case.
Yes, it's not just wide because you catch more cases and I'm acting for a claimant. It's going back to the statutory purpose of what this is seeking to achieve. We've got... is the defendant facing a stale claim, or has he only himself to blame on the one side? And on the other side, we've got a claimant who's being kept out of facts essential to his cause of action, without which he cannot bring a claim. So then one has to say, is it really Parliament's intention to say, unless you are in the minority of cases where your defendant finds himself under a legal duty to disclose, careful omission by the defendant will never trigger Section 32(1)b. And that, in my respectful submission, again, sets the antennae quivering. Because that can't be right. It just can't be right. You literally suddenly collapse Section 32(1)b into a very small subset of cases where it just so happens there's a duty of disclosure, when the word concealment doesn't even require that. That's why Lord Justice Buxton is saying, I don't need to look for this. I don't need to root around for a contractual duty, messing up the whole law between surveyors and ship owners or the like, and in another case, all sorts of other areas, creating in a limitation dispute a new duty of care, which will then be applied wantonly by others in due course. I don't need to do this. All I've got to do is ask myself, is there a duty in this case? And in essence, he's asking himself, is it fair and just that there be a duty here, to say that non-disclosure constitutes concealment. And all I've done is seek to translate that and say that is very much akin, in my respectful submission, to saying, is it reasonable, objectively reasonable in the eyes of the court, that non-disclosure should be treated as a concealment? And that flexibility is welcome. It is not just openness vis against narrowness. It is hitting the right targets. And the court can determine that it shouldn't hit a lot of targets, or it should, but the court is able to make its assessment. Otherwise, you're going to have a case, not a Section 140A case that happens to involve a legal duty to disclose, but a case which doesn't involve a solicitor with an ongoing duty of disclosure, or involves, because we come to this in Plevin, a solicitor whose retainer for that litigation has ended. Now, my learned friend gave examples yesterday. He said, well, I can't remember exactly the context, but the point he made was, well, of course, a solicitor a year later realises he's given some bad advice, is obliged to tell him. And he didn't seek to qualify that by saying a solicitor who continues under a retainer for his client in relation to that litigation, which it would have to be, because a retainer generally is of no help to anyone. He might be doing conveyancing for the rest of the year for the client, which has got nothing to do with it. Just a retainer doesn't cut the mustard. He didn't say that. His sense of the injustice mirrored ours, which is, indeed, that's right. A solicitor or a barrister, a year later, one advice, never instructed again, realises I've missed a tax statute. If I don't tell the client, who I can see very clearly hasn't worked it out, because he shouldn't do on the face of my advice, if I don't tell them, more fool me if he comes chasing me for money many years later. That's the Lord Millet point. You've only yourself to blame. I can always write and say, I'm sorry, in that advice, I've now appreciated I missed out this tax statute. It's Lord Justice Mayall's point in OT computers. Don't feel too sympathetic to them, because they can put it right and make sure the limitation clock is ticking. And it's that degree of flexibility which Parliament must have intended, not, can I list a category of cases which are incredibly narrow, of cases where the defendant is under, at the relevant time, an ongoing duty of disclosure. Otherwise, we get, additionally with the solicitor example, the case of a solicitor is under a retainer in relation to that litigation. He doesn't say anything. He should have done. That's case A. Another case, he's under a retainer. He doesn't realise that he's done anything. The retainer ends, and the day following, he conducts his omission, deliberate omission. In that case, allegedly, it's all over. It's too late. The happenstance of when the retainer ends. So that, my Lord, is what we're seeking to avoid. It's not just we want to capture as many cases as possible. We want to capture the right cases.
Yes, thank you.
The next question that I asked was the appellant under a legal duty to disclose? And in light of the observation of my Lord, Lord Reid, I'm going to really take that one shortly, because we've always said, of course, Section 140A. And again, it's then said, oh, that's not a legal duty to disclose, and points have been taken. It is. It's in the language that we're employing, because we have to remember we're not charged with a test by Parliament in words. Is there a legal duty to disclose? But we know that breach of duty in this context, being the obverse of right of action under 32.2, constitutes the failure to disclose the Commission. Section 140A bites. That provides the duty to disclose, insofar as a legal duty is needed. So then the appellant says, well, you can't rely on the same non-disclosure as constituting both the breach under 32.2 and the concealment under 32.1b, that they can't operate together in relation to the same facts. And we say, why not? And first, by reference to authority, my learned friend properly took the court to Sheldon, or at least mentioned Sheldon because we've set it out in our case. and then sought to distinguish himself from Sheldon. Just to take you to Sheldon in relation to this issue, can we start at 665? So we're in the judgment of Lord Keith, and this is one where Lord Keith agreed with Lord Brown-Wilkinson, Lord Brown-Wilkinson agreed with Lord Keith, and so forth, and we get lots of... And Lord Nichols agrees with both Lord Keith and Lord Brown-Wilkinson, so we end up with majority judgments from Lord Keith and Lord Brown-Wilkinson. At G, the terms of paragraph B, however, are wide enough to cover both the case where the concealment is contemporaneous with the accrual of the cause of action and the case where it occurs at some time later. So the Sheldon was, can it occur later? And the answer was yes, it can occur at the same time and later, and you get to the same effect, albeit it's not, it's the way it's put, you can see it at 667E by Lord Brown-Wilkinson, is he says...
Sorry, page again.
Yes, Lord, 667E.
Thank you.
Lord Brown-Wilkinson, my lords, were it not for the acute division of judicial opinion on the matter, I'd have little doubt that on its true construction, Section 32(1)b operates to postpone the running of time in every case where there's deliberate concealment by the defendant, whether such concealment was contemporaneous with or subsequent to the accrual of the cause of action. And then effectively the rest of his judgment says, I'm maintaining that position. So that drives my learned friend to draw a distinction between timing and content, where I think, because Sheldon establishes breach and concealment can occur at the same time, but he says, oh, well, it still doesn't say that the content can be the same. That's a very fine distinction that is not one that's made out there. And we see this in OT computers, and a case I've briefly referred to. So this is page 1817. Paragraph 18. It is in the nature of page 1817, para 18. It's in the nature of an unlawful price-fixing cartel that it's deliberately concealed from its victims, and in any event, operating such a cartel amounts to deliberate commission of a breach of duty in circumstances unlikely to be discovered for some time. So that would appear to be, I'm no expert on operations of cartels, but that would appear to be another good example of how you can have them operating at the same time. And that was authorities, but by reference to statutory language and purpose, 32(2) is, as we know, a deeming provision for 32(1)b, providing an additional route to postponement. So it would be going some way for this court to read section 32(2) as somehow limiting the scope of section 32(1)b. That doesn't make sense. And that there should be crossover comes as no surprise. See the observations from my Lord Reed, because here we happen to be dealing with a case where non-disclosure is at the heart of the case for fact of deliberately concealed fact and deliberate breach of duty. And then finally, I'll just give you the reference to Lady Justice Rose, which is paragraph 83 at page 193. When she rejects that, there's a submission which is being made. So you don't need to go to that. Reference is then made by my learned friend to the case of Kitchen, putting to one side that my learned friend, having sought an embargo on the pre-1980 case law, then embraces Kitchen when he thinks it helps him. Kitchen, in the section that my learned friend relies on, Lord Evershed says no more than that negligence in the commission of the breach of duty isn't sufficient. It's like Brocklesby. I don't take anything from Kitchen. Can I then come to the mental element needed in relation to those? Or the mental is the mental. Sorry, this is a submission that I needed to clarify earlier before lunch to my lords, Lord Hodge and Ree and Sales. This is the: is there a requirement under the current law that there is a mental element in relation to A, being under a duty to disclose, or that's the issue, the factors relevant to the cause of action. Now, again, on the facts of this case, we say the issue is not important, because if you just use the words the factors relevant to the cause of action, the appellant was reckless as to whether it was legally obliged to disclose the commission. That's Lady Justice Rose at para 157, page 215. If you're reckless as to whether you're legally obliged to disclose the commission, in ordinary language, you surely know the commission is relevant to a cause of action against you. And they knew they were under a duty of disclosure. They knew they were under a legal duty of disclosure. That I believe, is not an issue. And it's also in the judgment of the recorder. Pretty short. Short route out. So, at the level of the Court of Appeal, there's no requirement that the defendant needs the requisite mental element that the concealed fact is relevant to the right of action in addition to the obligation to disclose. And can I start with this case in the court below? Lady Justice Rose at page 211. Paragraph 1372. So at the top, please. Says Mrs. Potter can rely on section 32(1)(b) if she can show that Canada Square realised there was a risk they had a duty to tell Mrs. Potter about the commission, such that their failure to do so meant they deliberately concealed it. So that's duty to disclose, duty to tell. No reference to factors relevant. She made findings that they were reckless as to whether it was relevant. That's all at para 157, which is pages 215 to 16. And if we go to Lord Justice Mayles at page 225, my learned friend took you to para 199, where he gives a list. I hope I'm not rushing. Para 199, that's the list. That's where he took you to. If you actually go on then, having given the list, to paragraph 200, it starts, I should explain I've included recklessness in my summary of the questions which the case is required to address because I agree with Lady Justice Rose. In the context of section 32(1)(b), a defendant who is reckless whether a duty exists or whether a fact is relevant to a right of action, etc. So that's the Court of Appeal below. It just doesn't reference out what my learned friend wishes it to. And the whole submission is odd because if one goes to the Critique Palm at page 448, the judgment of Lord Justice Ricks, paragraph 321. this is supposed to be the fons et origo of all of this, and absolutely clear and followed by everyone. What Lord Justice Rick says is, it appears therefore there must be either active and intentional concealment of a fact relevant to a cause of action, or at least intentional concealment by omission relevant to a cause of action, which the defendant knew himself to be under a duty to disclose, not and which he knew to be relevant to a fact going to the right, relevant to the right of action. So it's not even in the test that my learned friend says is the one that's so clear and universally followed, and it's not in Lord Justice Buxton at 427 when you go to page 472, sorry. If you go to page 472, para 427, hence the confusion by me. So page 472, para 427, that exposition of the judge's application of it raised the following issues. 1. Was ITS under a duty? 2. Did ITS, knowing of that duty, i.e. the duty to disclose, decide not to reveal it? That's it. And this was held up as the test, but it doesn't even relate to the submission now made. Now, of course, this court can add on, take off, do what it will, because this is just in the Court of Appeal, but there isn't Court of Appeal authority to this effect. The Primio case, again, I'll just give you the reference, page 988, para 444, this is Court of Appeal Primio, just says the defendant must know it had such a duty. Loyally tracking, as my learned friend's submissions are right on, loyally tracking Rick's LJ. And in Williams and Fanshawe, the court is alive to the assessment made by Mr. Justice Park, so I don't need to rehearse that. Lord Justice Brooke, if one goes to page 829, para 51, just says, in the middle, he deliberately concealed its existence from her, although he was under a duty to tell her about it. And lower down, the claimant didn't know a fact relevant to a cause of action until a date less than 6 years before this action was brought. And the reason she didn't know it was that Mr. Brown intentionally concealed it from her when he was under a duty to tell her about it. No reference to an additional mens rea. Much more in line with what we say is our additional case. Is there deliberate concealment? Is it relevant to the cause of action? In other words, an essential part of the cause of action, not add-on new mental element. It's only Lord Justice Mance who introduces that, and that's at para 37, page 825. He has set that hare running, and it's a matter for this court what to do with it. And that's when, having set that running, his antennae are alerted, and he says, but of course you don't actually have to know that that's a claim that's bound to succeed. That's the passage in 37 that I took the court to before. That you've got to know that there's a potential claim. It says an actual or potential claim. And that's why I say on the facts anyway, that once you know there's a risk that you're legally liable, you obviously know that there's a potential claim. We shouldn't need really to get into all of that. Can you be reckless to duties of utility and morality and all those other complicated permutations? But a defendant who knows he's under who's reckless as to whether he's under legal duty to disclose, is surely knows that he's under a moral duty to disclose, or a duty in Limitation Act terms, is how we'd put it. That would, or you convert that into, it would be reasonable to expect him to disclose and unreasonable not to, if you apply an objective test, which I would have thought is simpler and more effective, but it's a matter for the court. I was next going to go to our additional case under 32(1)B up to 2010, but in response to questions from my Lord Sales, I think I've probably sufficiently addressed that. We do it at some length in our case. It's paras 97 to 119, pages 152 and following. And essentially it is to ask the question whether either is the omission to disclose deliberate or the concealment deliberate, and an omission to disclose that is unreasonable feels to us like a concealment, a way of getting to concealment. That is nowhere near introducing Brocklesby by the back door, nowhere near, although much play is made of that in the learned friends' written submissions in reply at paragraph 20. And the reason it's nowhere near, apart from we've got these additional elements, is that those examples and the example given yesterday of the horse that doesn't eat hay and all the rest of it completely omit the requirement that the fact has to be relevant to a cause of action. And relevant to a cause of action means a fact without which the cause of action is incomplete. Page 217, so we're in the judgment of Lord Justice Males, page 217. Paragraph 167. This is solid law. There's plenty of Court of Appeal cases on this. This is long established. Para 167, second sentence. That expression, that's fact relevant to the right of action, has been narrowly interpreted to refer to a fact without which the cause of action is incomplete. And he references Arcadia, but there are a number of cases. I think they're all in the bundle. It doesn't matter. It's in accordance with the statutory purpose there should be such a narrow interpretation. If the claimant can plead a claim without needing to know the fact in question, there's no good reason why the primary limitation period should not apply. That's FII too. That's understanding the core point. That's Lord Justice Males' insight, not just saying, oh, this is a test and this is applied and I'm just going to sort of apply it without thinking. He's saying, of course, that's got to be right, because this is all about denying a claimant the right to bring a claim before they ever had the tools to bring the claim. And if you've got the tools, you can't complain. So the facts that have got to be withheld from you are the facts that are essential to the right of action. And all of a sudden, the example my learned friend gives collapses, because if it's right that silence is golden in that contractual case outside of a consumer context, you've just got a buyer and a seller, and of a horse that doesn't eat hay. His example is premised on there's no breach of contract, because it's caveat emptor. If there's no breach of contract, there can be no deliberate concealment of a fact, because nothing's happened. So his example is meaningless. It only applies if there's a problem, if there's a breach of contract, if in fact you are obliged to tell them that the horse doesn't eat hay, and you discover at some point that it can't. Then it becomes interesting. But otherwise, I'm afraid, it doesn't bite. I can say that. So that is an immediate limiter on the application of section 32(1)B. It's no good giving examples in which there never is a breach in the first place. Finally, can I come to our post-Plevin case? And obviously, to get to post-Plevin, things have had to go somewhat awry for us at various stages, and it's possibly a bit too hard to work out exactly every which permutation again, but essentially the court would have to, I think, find, for this to become relevant, that there can be no recklessness. That won't suffice. There has to be knowledge of the actual legal outcome. The only time that this...
knowledge of the
actual legal outcome. And because there could be no knowledge of the actual legal outcome pending Plevin, therefore no part of 32 bites. That's the only way in which this becomes relevant to the court. And it then becomes relevant because post-Plevin, the defendant unequivocally knows that it is legally liable, because the percentage was 74 point something or such like in Plevin, and it's 95.24% in this case. So they don't have the problem of, oh, well, our percentage isn't quite as high, so maybe this one's not unfair. And that point was expressly conceded before Mr. Justice J at paragraph 23 at page 188. Sorry, 236. I apologise, that was a key documents pagination. 236. And if you'll see if it goes over the page. Mr. Snoot, the basic point is his client couldn't have known they were under any duty at all until 6th of April 2007, and the relevant jurisdiction did not fix them with the requisite knowledge until the publication of the Supreme Court case in Plevin. Now, by that time, there isn't an ongoing Section 140A legal duty, so we're now in the world of Duty and Limitation Act terms if we're in Court of Appeal analysis. And the position, we say, would then be materially akin to the Critti Palm. The contractual obligations are at an end, but in common sense and Limitation Act terms, it challenges those to say that the appellant, knowing it's legally liable to the respondent, and in the knowledge that there's no reason for the respondent to know any different, shouldn't be held to owe a Limitation Act duty such that their failure to make contact constitutes deliberate concealment. That's all within the 6-year limitation window. It's their choice. And one hears from my learned friend's frank submissions yesterday, they made a choice. They made a choice. They elected not to. Their call. It goes back to Lord Millett. Don't blame anyone but yourself. You can stop, you can make sure the limitation clock starts to run in 2014 and tell people if you want to. But if you don't want to, do not come and complain later. So that's an application of my learned friend's unqualified example of the solicitor who gives an advice and realises a year later, as he said, that he's missed out some relevant tax statute or the like. It's materially no different. And if you analyse it in terms of our additional submissions, then it's relatively straightforward. They've elected to continue not to disclose the commission when they know that its non-disclosure renders them legally liable. And such non-disclosure is plainly unreasonable and so qualifies as concealment. Brief reference has been made to a judgment from Mr. Justice Fraser, which isn't before the court, suggesting that you can apply Sheldon after the expiry of the limitation period. That doesn't arise in this case. One can be very circumspect as to whether that's right or not. It would undoubtedly be a matter for the higher courts to determine. Not being argued, it's not necessary to argue it today, and it's really being applied in a sort of inter rorem basis to say, please don't let this apply. It'll just apply everywhere and every time. It's just not necessarily or appropriate to address that issue because 2014 is within the 6-year window from 2010. It's not an issue before this court. Lord Solicitor, unless I can assist further, and I'm grateful for coming in before 2 o'clock, and those are my submissions.
No, thank you very much indeed, Mr. Weir. Yes, Mr. Kimmins.
My Lords, a few points to pick up. One preliminary point is this. My learned friend made submissions to the effect that any claim would have to be under the terms of the loan, not the PPI policy. I would caution the court about going down that route at the moment in the absence of full argument, because that is a point which I'm told is live in another case for which permission has been sought to come before your lordships, I think. And therefore, I wouldn't want that issue to be prejudged in any way in the absence of full argument. And I certainly am not able to assist your lordships on that particular point of law. I'm not in that case. My learned friend is. And therefore, we would encourage you to steer away from that particular point at the moment. That's just one preliminary point. As to the other points in reply, I'll try and take them in a logical order of some kind, but forgive me if I skip around a little. Purpose and structure of Section 32. Our case remains that it's all about improper conduct. My learned friend tries to water that down a little and says, well, really, if you can make a clean breast of it, he says, by contacting the claimant, then that's really the nub of this. You only have yourself to blame. That's essentially the point. But that would occur. That would apply in every case of non-disclosure. Every case of non-disclosure would inevitably involve that. There are all sorts of other cases which would attract that particular point. It has to be something narrower than that. And we do draw your lordships back to those dicta in Sheldon to the effect that what we are after here is improper conduct. And then as to certainty, my learned friend took a point along these lines. He said, well, listen, as long as the test is clear, the application of the test to the facts need not be. But we say, no, that's not right. The whole point of the dicta of Lord Sumption and various other dicta is to the effect that the package has to be such that it is predictable and one can assess whether or not a claim is time-barred. And that will involve not only the law, but how easy it is to apply that particular provision. And it's for that reason that we do maintain the point that duties such as moral utilitarian duties are far too vague. It's all very well to say, well, that's the test. You know the test, it's in the judgment, and therefore that's the only hurdle I need to get over. We say, no, that's the wrong way of looking at it. It has to be the application of the test to the particular facts as well, which must be certain, otherwise you're defeating the statutory purpose. In relation to 32.2, I made lots of submissions earlier on about the language. My learned friend says, well, again, it all depends on context. I would invite your lordships at some point to go back over those cases, such as Mutual Star. The dicta in those cases is wide, and what it does is reflect the ordinary meaning that the ordinary person would give to those particular words. And of course, there are a myriad of cases in which it's emphasized that what you're looking at is words to be construed such that any member of the public with legal advice could look at a statute and say, well, I know what that means. And we do say that the words deliberate commission of a breach of duty are thoroughly straightforward and simple and mean precisely what I was trying to persuade your lordships yesterday they do mean. And you do have complete unanimity in terms of meaning in every single one of those cases, and a complete absence of any cases pointing the other way. On the authorities, my learned friend says, well, Lord Millett implicitly approves King versus Victor Parsons, and that case refers to recklessness, and therefore he must be endorsing recklessness. We say, no, that's not what he was doing when he was setting out that passage from King and Victor Parsons. What he was saying there is essentially 32.2 was added to catch a bully-type breach, and that's what he was referring to. And you'll also note at the bottom of the passage, quoted from Victor Parsons, in Cave, there was an italicized section, which essentially said negligence is not enough. And therefore, that at best is what he was referring to. What he wasn't saying is, I endorse the concept that recklessness does suffice. That would have been contrary to the common ground between the parties in that case. And that's a point I made yesterday. I'm not going to hark back to it. But we do say that had the court been of the view that the common ground was wrong, they would have said so. Leaving authorities to one side for the moment, one then has the policy considerations. And this was essentially my learned friend's big point. And he said, well, you just don't know whether it's going to be a breach of duty. How can you tell? And we say, first and foremost, it is plain on the authorities that you have to know that it is a breach in a legal sense. And the neatest way of seeing that is from the discussion in CAVE of arguments along the lines of well, you're deemed to know the law. And it cannot be about knowing legal consequences. And essentially the point made by Lord Scott in response to that is, well, it is, because that's exactly what this clause says. Subsection 2 says you have to know that you are committing a deliberate breach of duty. And you see this at 537 of the CAVE case. And as I say, it's something of a cri de coeur, because you can see Lord Scott saying, that's what it says. And if one looks at 61, at the bottom of 537 in CAVE, you'll see Lord Justice Morritt said in a passage I've cited that in general a person is assumed to know the legal consequences of actions, and that therefore if an act has been done intentionally, the actor's unawareness of its legal consequences would be immaterial and no defence. The premise is, in my opinion, much too wide to constitute a satisfactory approach to construction of a statutory provision such as 32(2). A person may or may not know that an act of his or an omission to do or say something or other constitutes a breach of tortious or contractual duty. His knowledge or lack of it may well be immaterial to the question whether a cause of action for which he's liable is accrued to the person injured by the act or omission. But that is no reason at all why Parliament, in prescribing the circumstances in which the person injured by the act or omission can escape from a Limitation Act offence, should not distinguish between the case where the actor knows he's committing a breach of duty and the case where he does not. The clear words of section 32(2), deliberate commission of a breach of duty, show that Parliament has made that distinction. So we do say that the one cannot get away from the words. And there will, of course, be cases where it's quite difficult. And the panel, during the course of argument, raised various points and said, well, what if somebody is sufficiently legally qualified that they happen to know that what they're doing is a breach of duty and a legal wrong, and the other person doesn't? Well, the answer is tough. You've got to know that what you're doing is a legal wrong, and that is because that is what the section says. And we say that in practice there will be very few cases which create extreme results in this type of scenario, because 32(2) was, of course, if one goes back right to its genesis, it's a classic bully-type breach, the stealing of somebody's coal. It's that type of case which so obviously fits within it. That is the type of case which gave birth to this particular point. And therefore I take entirely on the chin that there may be some people who do something similar but know more about whether or not that constitutes a legal wrong than others. But that is what this very section is out to catch. Because, of course, it's only if you know that there is a legal wrong that you can ever be accused of deliberately concealing anything, we say. That's what Section 32 is all about.
Yes, bully is about trespass.
Indeed.
Which involves knowingly entering another person's property without permission. So you say in that context, you know you're breaching a duty.
My lord, yes.
And that's... Beeman is about conversion, which again I think involves knowledge.
My lord, yes. I mean, we say that involves knowledge as well. And these are all classic types of cases which involve actual knowledge. You know that what you're doing is a legal wrong. And that is what the section is there to catch.
What about a breach of contract? What about the person who puts in the foundations which are inadequate and then covers up?
Well, if he knows that the foundations are inadequate, then he knows he's in breach of contract. And that's a classic 32(2) case. Yeah. If he then tries to cover it up afterwards, he may also be guilty of positive act concealment under the first part of 32(1)(b).
But if it's merely negligent building, you would say it's not caught by 32(2).
no, not unless he knows that he has been negligent. So that builder is caught. And there's sense in that, because it's in those circumstances that one can see some sense in punishing somebody for deliberately concealing facts which could be the subject of a cause of action that he knows is established. And in those circumstances, you can see that you would say, well, yes, that makes perfect sense. I do reiterate again and again, I'm afraid, that the point that one can't get away from the language of this, and it's exactly that point that Lord Scott is making when he says, I know there's a principle floating around in the background that ignorance of the law is no defence, etc., but that is what Parliament has done here.
Well, on one reading, for example, when he says the case where the actor knows he is committing a breach of duty. Now, if the approach, I mean, earlier on, he like Lord Millett, in bottom of 58, contrasts deliberate wrongdoing with negligent or inadvertent wrongdoing. And if you look at if you ask yourself, what is the breach of duty? And say in negligence, the breach of duty is a failure to take reasonable care. You can commit the tort of negligence. you can fail to take reasonable care deliberately, in which case that's that's a deliberate breach of duty. Or you can do so negligently, without thinking about it at all. If you do it deliberately, then you are, in Lord Scott's words, well, you're doing, in the words of the Act of Parliament, you're deliberately. What's in 32.2? It's deliberate commission of a breach of duty, even if you've never opened a tort textbook in your life and never heard of Donoghue and Stevenson.
Well, my lord, if you ask me where do I draw the line, I don't say that you have to know the specific provision, but what you have to do is know that you have committed a breach of duty in the sense of a legal wrong.
Well, I'm wondering about that, because you are then driven into the logical paradox problem that we struggle to find a way out of in FII.
Well, I'm not so sure, my lord, because in FII, the paradox was slightly different. It's something we explain in our reply. If one actually tries to identify the paradox point here and how it works, it's really, my learned friend, saying nothing more than that it is difficult to prove that somebody knew they were committing a legal wrong. That's essentially what it says, because my learned friend says, well, you're only going to know that when you've been found liable.
Well, yeah, but that's exactly what Lord Scott says is, where is it? I think what he says is necessary. Paragraph 60, page 537.
Yes.
He says, about halfway through the paragraph, there's a sentence beginning, subsection 2, however, provides an alternative route. If you're with me.
Yes.
The claimant
need not concentrate on the allegedly concealed facts.
Yes.
But can instead concentrate on the commission.
No, I'm sorry, this is dealing with the issue of concealment.
Yes, but then, I mean, if one reads on, if the claimant can show that the defendant knew he was committing a breach of duty or intended to commit the breach of duty, I can discern no difference between the two formulations. Each would constitute, in my opinion, a deliberate commission of the breach. So, again, one has clear dicta, we say, to the effect that you've got to know that it's a legal wrong. And if one looks at 823 as well.
That makes it unworkable if you have to end up in the House of Lords, or nowadays this court, before time can begin to run.
Well, but my lord, we don't accept that that's the position. That may or may not be the position. In 99 cases out of 100, it'll be perfectly clear whether or not somebody has known. There may be some cases where the breach is sufficiently arguable that it will only be finally clarified if you get to court. Fine. And in those circumstances, you're not caught by 32.2. But in an ordinary case...
A limitation plea doesn't depend on establishing what the legal position actually is. I mean, if the claimant pleads a cause of action and the defendant pleads limitation in defence, and it goes to a preliminary trial on that issue, the judge doesn't have to determine whether such a cause of action actually exists or not, which might be a very difficult question. But the issue that arises under the provisions we're looking at is on the assumption that there is such a cause of action.
Yes.
Did the defendant deliberately commit a breach of the duty relied on?
My lord, yes. And at that point, you're getting inside the head of the alleged contract breaker. And he either did or he didn't. And that's what 32.2 is after.
And the true state of the law doesn't matter.
Well, my lord, ultimately, whether one is in breach or not, I agree, that happens later down the line. But that doesn't stop you from determining whether or not somebody was of the view that what they were doing was a breach of contract. And you can decide that at any point. You don't need to have determined whether or not it was, because that's a different question. You're looking at whether the person involved believed. So it's awareness, belief. Belief is almost, in some ways, perhaps a more accurate word. That at the time that that individual is alleged to have done A, B, or C, were they of the view, did they believe that what they were doing was a breach of duty? And if they do, then it's caught by 32.2, and if they don't, then they're not. And hence the logical paradox point along the lines of, well, you inevitably have to, or indeed that you cannot in fact ever know until it's been resolved in court, we say doesn't work. It's different in F2, and we explain this in our reply submissions, where on the facts of that case, you would only ever know whether you had made a mistake when the court has decided whether a mistake has been made. And that's a different paradox, and we deal with this in our reply submissions. But I do maintain the point that if you distill my learned friend's submission, it comes down to, instead of being some paradox impossible to solve, it comes down to the simple submission that it's difficult to prove that somebody knows they are in breach of duty. And we say, so what? And my lord, there are other clues. If one looks at 823 and looks at 31, this is Lord Justice Mance, and he says at 31 at 823, Cave's case decided that the wording of 32.2, deliberate commission of a breach of duty, requires the defendant not merely to have intended to do an act which constituted a breach of duty, but also to realise that the act involved a breach of duty. He has to realise, be aware of the fact that that act involved a breach of duty. And all one is doing there is simply applying the natural meaning of the words. And you see language such as that replicated in almost all of the authorities. If one looks at page 79, for example, and this is in the midst of the appellant's case. And you've seen all these before, but just to remind you of them. Look at Mr. Justice Coulson in paragraph 26. There's plenty of authority to the effect that the use of the word deliberate in the context of a breach or default means an intentional act. In other words, a breach or default which a relevant party knew at the time that it committed the relevant act was a breach or default. And so you've got to know what that consequence is. And you get this from all these cases, but not least from the point made by Lord Scott in Cave, where he said, it doesn't assist you to start taking points along the lines of, well, you may not know the legal consequence, because that's what this section is all about. And it's all about that, because in those circumstances where you know the legal consequence, you can duly be penalised for having done that in a surreptitious fashion.
It means the provision really doesn't work in relation to people who don't know the law, on the one hand, or people like Supreme Court justices or leading counsel who have a very sophisticated view of the law and know that almost every proposition is contestable.
Well, they may not know, my lord, that the precise statutory subsection, they may not know that it is section A, little 1, 2.
No,
but
a straw man.
Fair enough, my lord, straw man indeed. But they do need to know that what they have committed is a legal wrong. And that is what this is getting at, and that is the only construction which is consistent with the language which is used. It has to be the deliberate commission of a breach of duty. And my lord, I do pray in aid of the fact that this point was taken elsewhere along the lines of a lawyer knows more about the law than others. That's exactly the point which was taken in support of Brocklesby. And they said in Brocklesby, well, in circumstances such as that, you're assumed to know the law. It's no defence to say that you don't know the law. And that's exactly what the Supreme Court was addressing in Cave. They said, hold on a minute. It's all very well taking points such as that, which have validity in other areas of law. We are looking here at 32.2. Look at the language. You've got to have a deliberate commission of a breach of duty. And that's what Lord Scott is saying in that paragraph, which I drew your attention to at the beginning. There are other wrinkles. Of course there are other wrinkles, such as what happens if the person believes that their conduct is such that they have a defence to a claim for breach of duty, and on that hypothesis they do not consider they are in breach of duty. And therefore, if they're not in breach of duty, they don't fall within the section. And it's all well and good and many hairs can be split in this context. But one has to take a step back and look at what they were trying to do, which is punish improper conduct. It makes perfect sense to limit that to circumstances where they know they are in breach of a particular duty. And we say that difficult cases are likely to be rare, and we say be wary of applying the F2 case paradox scenario to this case, because we do say very different considerations apply.
Sorry, can I just check? I haven't found the start of Cave. Did others agree with Lord Scott?
My lord, yes.
Who agreed with Lord Scott?
Yes, they did.
Sorry, it's my fault for missing the page reference.
So you have, hold on.
Well, don't take it.
I have got all this written down because, yes, 524. So Lord Slynn agrees with Lord Scott. Lord Mackay agrees with Lord Millett and Lord Scott. Lord Hobbshouse agrees with Lord Millett and Lord Scott. And Lord Millett starts, I've had the advantage of reading in draft the speech of my noble and learned friend, Lord Scott of Foscott.
Right. So curiously, Lord Slynn didn't agree with Lord Millett, though both the others.
Yes.
All right. Thank you.
Yes, it's not as bad as Sheldon, which is impenetrable to work out who agrees with who.
All right. Thank you very much.
My lords, so that I hope is our answer to the public policy considerations which my learned friend takes in relation to that particular paragraph. We just say apply it as it is. It says what it says. Looking then at legislative history, my learned friend says, well, Lord Millett says you can identify the mischief which the later statute set out to remedy, or explain why Parliament chose to adopt the particular language or drafting technique which it did when enacting the later statute. As to that, we say, well, the later statute, the mischief which the later statute sought to remedy was the fact that the previous law was unbelievably unclear in both effect and terminology. And it's for that reason that Lord Millett then says, you cannot assume the law is the same. And when one gets to that particular point of the analysis, with Lord Millett saying, you cannot assume the law is the same, we say that is the end of it. In those circumstances, there is absolutely no benefit whatsoever in dragging anybody back through those various authorities. And the other half of the sentence, which my learned friend relies on, is you can also look at it, to explain why Parliament chose to adapt the particular language or drafting technique. And of course, that doesn't apply in circumstances where one has here extraordinarily different language, which changes over the course of the passage of the bill through Parliament. Circumstances such as that, you really don't glean anything from going back over those old cases using entirely different words. So that's that. As for the statement of Lord Hailsham, my learned friend says, well, Lord Hailsham says unequivocally that the law should not be more restrictive. We say in relation to that, if one reads that passage carefully, all he is saying is the law should not be more restrictive in the sense that it should also cover a bully-type breach. So in other words, he was nodding there, acknowledging the fact that 32.2 was the first statutory section which dealt with a bully-type breach. And he's saying no more than that. My learned friend says, well, my fallback argument on 32.2 is that you need to know the constituent elements only. And we say, well, precisely the same answer to that arises. Look at the judgment of Lord Scott, where he says, no, you don't. You've got to know that what you are doing is a breach of duty. It's no good simply saying, well, you know that you did X or Y. And that, we say, is harking back far too close to Brocklesby-type cases. And Lord Scott is absolutely clear that you've got to go further than that. If you bear with me. Positive act concealment, just a few words on that. If I could just show you a couple of references. First of all, page 53, please. And I would just draw your attention to this because my clients do take great umbrage with the idea that this could be raised at this late stage. At 53 at the bottom, in paragraph 16, before Mr. Justice Jay and subsequently before the Court of Appeal, it was common ground that whilst the appellant made an intentional or deliberate decision not to disclose the commission to the respondent, there was no active concealment in the sense of positive action being taken to conceal. The case before Mr. Justice Jay and subsequently before the CA and therefore not about the taking of active steps to conceal the receipt of commission, but rather one of non-disclosure by the appellant. This non-disclosure has always been the only factor which has been relied on by the respondent as making the parties' relationship unfair. And that is unequivocal. Always. It has always been a non-disclosure case. And we do not accept for a minute that there was ever any positive plea of positive act concealment. And my client does feel very strongly, and I am instructed to say, that had that plea been made, this case would have taken a different shape because of the reputational issues which arise in relation to that point. So I would also draw your attention very quickly to page 238, please, which is the judgment of Mr. Justice Jay, and at paragraph 28, you'll see there Mr. Justice Jay in the third line. This is not the present case where he's talking about active steps to conceal. This is not the present case here because the appellant made an intentional or deliberate decision not to reveal the commission to the respondent, in my opinion, for obvious commercial reasons, but no positive action was taken. So the instant case is not about the taking of active steps, but rather non-disclosure. So again, all consistent with the way the case had been run from start to finish. And therefore, it is perhaps unsurprising that my clients do feel very strongly about that point.
And what do you say about the pleadings then? Because, I mean, you've shown us Mr. Justice Jay, but of course the trial was before the recorder against the pleaded case.
Yes, but there was
shown the reply in page 283.
Yes, but we say there was no plea of positive act concealment. And it's all very well to say, well, a fact may have been pleaded, but my clients have to be able to understand what the consequence of that fact is. They may or may not choose to dispute a particular point, depending on their view of what the consequences of a finding against them on that point are. And suddenly, it is now being said that a finding on a particular point has a very substantial effect, which is that it moves the case into positive concealment, and as soon as you move it there, my learned friend says, you don't need duties to disclose at all. You're outside of Critty Palm, and hence it takes on a completely different shape.
I see the force of that. I mean, the statement of facts and issues is intended to be an agreed statement of facts and the basis on which this court determines the matter.
My lord, yes, and it says from the very beginning.
Yeah.
And in any event, we don't accept that there was any hint of a plea of positive act concealment, and it has huge consequences if you do have a positive act concealment under the law in the Critty Palm, because as soon as you move away from positive act concealment, you're in non-disclosure with all the duties and all the rest of it, and that's why the case would have taken a very different shape had that point been taken at the outset. Legal duty or moral utilitarian duty. I went on about that at some length yesterday. All the points obviously relating to certainty still remain. As to tortious duties, just 3 references for your note. Those tortious duties were very much in play in that judgment, and the paragraphs are 186 at page 414, 329 at page 450, 353 at page 456.
The middle one, please.
Was paragraph 329 at page 450.
450, thank you.
And the first one, please.
The first one, apologies, I went too fast, was paragraph 186 at page 414. And one will see in all those paragraphs reference to negligence or tortious duties or whatever. And the one point my learned friend doesn't have an answer to, we say, in relation to what Lord Justice Buxton was finding, is the fact that Lord Justice Buxton recognised that Mr. Justice Park's alternative analysis was not one which this court was going to accept. And that is the only basis for saying, well, hold on, there shouldn't be a legal duty. It was a point made by Lord Sales. And he's right about that. That once that point has gone, it is obvious that Lord Justice Buxton could not then be saying, I am going to go with the argument that you don't need a legal duty. And furthermore, the other unanswerable point is that if that's what he had been finding, he must have known that he would have been differing from Lord Justice Ricks and the underlying trial judge. And therefore, he would have explained the position very carefully. And that, again, is clear. And if one looks at the very last sentence of the judgment, where it says, I allow the appeal in relation to deceit, full stop. That's it. He doesn't overturn or make any comment on the judge's underlying findings, which are all about legal implied terms. Was there a legal duty to disclose? We rely on Mr. Justice Jay, who in turn relied on Lord Sumption. And the point is a very short one, and I went through it previously, but essentially Lord Sumption was saying that there is no legal duty, but that doesn't mean that you cannot be in breach of Section 140A. But here we are looking for a freestanding legal duty to disclose, and we say there simply isn't one. Recycling the same conduct, in relation to that, I would just remind your lordships of paragraph 139, we needn't turn it up, which is at page 115 of Lord Millett in Cave, where he summarises the 2 types of scenario which fall within Section 32. In my opinion, Section 32 deprives the defendant of a limitation defence in 2 situations, where he takes active steps to conceal his own breach of duty after he has become aware of it. So you can see there that what's contemplated is a classic scenario of a breach and then an awareness and then concealment. And that, we say, cuts right across the idea that you can recycle the very same conduct. And the same language you will find in Beeman at page 490. The page, internal page in the report is 559, but it's 490 of the electronic bundles, where there is an introduction to bully-type breaches, and it's all about subsequent awareness. Now, I entirely accept that it doesn't have to be subsequent as found by Sheldon, in the sense that it can be contemporaneous. And you'll see the word used in Sheldon is contemporaneous, meaning it happens at the same time. But as I explained yesterday, that doesn't mean that you can recycle the very same act. And contemporaneous, a classic example, as I said, is a solicitor who is negligent and knows that he is negligent. He deliberately commits a breach, and he then becomes, at that very second, contemporaneously, he comes under a self-standing legal duty to report that negligence. And so in those circumstances, you have a contemporaneous breach and contemporaneous concealment, but it's two different points. And we don't accept that you can simply recycle. And we do say that Kitchen is bang on point in relation to that particular issue. My Lords, the lady solicitor point, if I could just draw your attention briefly to Williams. There is a debate between myself and my learned friend as to whether Lord Justice Males, when he used the word "and" in that famous paragraph we've looked at a number of times at the end of his judgment, where he lists numbers 1, 2, 3, and then 5. I say "and" means "and." My learned friend says it means "or." Look at the paragraph afterwards. I took your lordships yesterday to the paragraph before, on the previous page, where it was plain that Lord Justice Males saw it as additional. And what he says, Lord Justice Males, is it's obviously additional, and that indeed is what Lord Justice Mance was contemplating in Williams. And he's absolutely right when he says that, because if one looks at 825 of Williams and looks at little c, so 825 at little c, he's been debating there the fact that you need to know that you're under a duty. And he says just above C, the deliberateness derives from his knowledge that he ought to disclose and his intentional disregard of his duty to do so. So he knows he's under a duty, and he knows that he is not following that duty. But whether this is sufficient, that's the key, whether this is sufficient in the particular statutory context of 32(1)b is a different matter. So he then considers whether you need the additional leg, which became Lord Justice Males' item 5 in that paragraph, of knowing that a particular fact is relevant to a cause of action. And so Lord Justice Males was absolutely right to say these are not alternative mental mens rea required for 32(1)b. They are additional on the traditional analysis from the Court of Appeal. And indeed, it makes sense that you need both. If you just needed to show that you were under a duty, then you have the classic lazy solicitor example. And what would happen if you only needed to show that you knew it was relevant to a possible claim? All sorts of difficulties could arise. If you knew that somebody was going to bring against you an utterly misconceived claim, and you were 100% certain that this claim was hopeless, and therefore you don't consider you're in breach in any way, you don't consider you're remotely culpable, but you know that your contractual counterparty thinks that X, fact X, is incredibly relevant and will be relevant to a claim against you. Have you got to say, well, this is the most hopeless case, but do you know what? I'm going to have to disclose it. Otherwise, I'm guilty of a deliberate concealment under section 32(1)b. We say that simply demonstrates why that could never be enough. So you have to have them both. They dovetail well together to achieve the statutory purpose. My learned friend teases me and says, all my horse and hay examples are all hopeless. But, of course, I did have in mind that there would be an underlying breach, which, of course, would be a breach of the warranty of satisfactory quality. And the whole point is that when you are in contractual negotiations, you do not know at that point what claims may be brought against you. And what troubles us on this side of the court is the idea that in contractual negotiations, you know that there is something which your contractual counterparty will not like. You don't know precisely what claims you may or may not bring. It may be relevant to a particular type of claim, it may not. But what happens if you have this swinging, all-inclusive duty of disclosure, failing which you lose your rights to rely on the statutes of peace, is you scratch the back of your head and say, well, I think erring on the side of caution, I think I better disclose this. And we say that's why it suddenly introduces into English law a principle which is directly contrary to some of the most attractive characteristics of English law, which enable you to drive a hard bargain in arm's length negotiations. So I do submit strongly that we always had in mind that there would be potential underlying breaches in all those examples. With 1 minute to go, just one point on post-plevin duties. Could I show you, please, page 2511, which is from our responsive submissions. And at 2551, there are 2 points that I want to make and reiterate. They arise out of paragraph 47. And you'll see there that the first point we make is that Mr. Justice Jay found, and there has never been an appeal against this point, that no duties of any kind subsisted beyond the end of the relationship in 2010. And per Mr. Justice Jay, counsel for the claimant also advanced a fallback submission based on the position post-March 2010, but in my view it's not arguable that any continuing responsibilities were owed post-termination, however these may be characterised. That finding was not appealed. I'm reading from over the page at 2512. Further, and consistent with this analysis, even after 2014, the FCA did not require lenders to review all pre-plevin cases to see if the commission had been disclosed. And just in relation to that point, my learned friend teases me about referring to the FCA and the ISOB rules from time to time. But of course, all the way up as far as 2012, Harrison and Black Horse is all about the ISOB rules. That's where the focus was. My Lords, if you'll excuse me while I just check if there...
Yes.
My Lord, that takes me to 4 o'clock.
Well, don't feel you are compelled to stop. I mean, you haven't had the time you had requested. If you,
my Lord, I'm a little short, but I don't think there are any other points. I'm sure I would be nudged from behind if there were.
Yes, Mr. Weir.
My Lord, I was just in response to an observation from my Lord Hodge vis-à-vis the state of the Statement of Facts and Issues. We did raise it in the Statement of Facts and Issues. It's page 64, my Lord, 44.2. I would hate for that to be missed.
Page 64?
64, my Lord. At the top. It follows, paragraph 44 says, the respondent raises the following further issues for consideration by the Supreme Court. Little 2 at the top, my Lord.
Yes.
Did the appellant act rather than omit to act when not disclosing the commission?
Oh, yes, you've raised the issue, but against the factual background that is set out.
I'm sorry, I misunderstood the point. I was just seeking to ensure, my Lord, that your Lordship...
No. I mean, I was aware you wished to raise the issue. It was the fact that paragraph 16 that you were referring to earlier.
Well, my Lord, that I can assure you is no more, no less than my misunderstanding of what needs to go into Statement of Facts and Issues in the sense that the issue was raised, they understood that it was raised, it was clearly a referral back to Lord Justice Males, and I'm not sure if in the facts and issues we should then be setting out what Lord Justice Males has said. So I'm not sure how I would put it any differently now, but that really is a technical point in that sense, my Lord, if I can respectfully put it that way. We've sought to put the issue before the court. My learned friend understood the issues before the court, and it may be a failure in the drafting of the SFI, but I'm not quite sure I'd do it any differently now.
Thank you.
My Lord, have nothing further to add.
Well, we've been anxious that despite the interruptions that we suffered yesterday, you shouldn't feel that you've been deprived of adequate time to present your arguments. It's obviously an important case. If you're both satisfied that you've said what you need to say, then we're very grateful to you both for the quality of the submissions that you've put before us. I think in reality we'll probably find ourselves handing down judgment in this case and in Primeo at the same time. And Primeo has a number of other issues as well. So we will produce our judgments as quickly as we can. The court will adjourn.